Welcome to BoormanLawyers. Today we are going to look at a high-range drink driving offence we appeared on at Waverley Local Court in Sydney.
G'day, it's Josh Boorman here from BoormanLawyers. Today I appeared at Waverley Local Court on a high-range PCA or high-range drink driving offence. It's quite a serious offence because the blood alcohol reading was obviously above the 0.150 limit in the high range, but it was quite well above that at 0.178. Circumstances surrounding the offence were basically our client had been working in the rural town of Tamworth. He had received some pretty unfortunate and bad news from back home where he lives or used to live in Ireland, that a friend had just been diagnosed with cancer, and he didn't have anyone around to have any emotional support or anyone to speak to about this. So he made the very poor decision of driving straight to the pub and drowning his emotions by drinking alcohol in excess, something that he would usually not do. But that's all within the law until he got to the point of such high level of intoxication that he made an absolute reckless and poor decision to get into his car and drive a short distance down the road to where he was staying at the motel. So it was at that point that he actually broke the law. He unfortunately came to the attention of police due to the fact that he was swerving and he wasn't driving in a normal or prudent manner. So they pulled him over and he recorded the high range reading of 0.178, which was, as the magistrate said, he wouldn't have been in a position to make a normal or sound judgment or decision in the state that he was in. What we did do, we explained those circumstances to the magistrate and indicated that this is very uncharacteristic sort of behaviour for our client. It was due to this very unfortunate emotional event that triggered him to act in a way that he usually wouldn't by drinking alcohol in excess. And we also were able to tender a number of documents in support of our client. We got him to put together a letter of apology, which we helped beef up and clean up and put before the court. We got his girlfriend to do a letter in support of him to show what a responsible partner he usually is and how he is the main income earner for their household. We're also able to get a letter from his employer confirming his employment with them, and that the fact that his driver's license is a significant requirement as a part of his employment, and that without his license he will struggle to be a part of their team at work. We got all those documents together. We also got another document, a character reference for our client to show that he does take part in his local sports club and helps out and volunteers from time to time. So we got all that together. We also were able to tender a completion certificate from his completion of the traffic offenders program, and this went a long way, given it was his first drink driving offence, to show that he has taken some proactive steps to re-educate himself on driver safety and learn more about his responsibility as a driver on our roads. So this was all well received by the magistrate, and we were able to get his period of disqualification reduced down to the minimum period of 6 months, and that was backdated to the date that he lost his licence on the date of the offence. In New South Wales, all high-range drink driving offenders must commit to the mandatory interlock provisions, which means that they must have a interlock device put into their vehicle for a minimum of 2 years after they receive their licence back from being disqualified. So there was no escaping this, and we prepared our client that he had to commit to the interlock provisions and device to be put into his car. So that was set down for 2 years after he got his licence back in 6 months' time. But the other really good result that we got today was the fact that we persuaded the magistrate not to issue any financial penalty or fine for our client in relation to this offence. And our basis for receiving that was that our client, having to do the alcohol interlock program, would still have to expend some money on having the device put into his car, having it calibrated and assessed once a month. So this would come at a significant expense to him in any event. And for that reason, the magistrate agreed and did not issue any financial penalty. Our client was really happy. He was happy that he didn't get any further financial penalties, and he was able to receive the minimum disqualification period for that type of offence, which would mean that he would be able to get back on the road sooner and focus on earning an income and working hard in his chosen profession. So guys, it was a serious drink driving offence, but we put together a well thought out and well prepared case. We know the magistrates out at Waverley, we know how they think, we know what their attitudes are towards these types of offences, and we know how to approach them. We also know have good working relationships with the prosecutors, and there was no problem or objection coming from the prosecution side. So if you found yourself in the unfortunate situation where you've been charged with a drink driving or drug driving or serious traffic offence, rest assured we specialise in this area in New South Wales law. And if you want to give me a call on 1300 941 900, I'm happy to have a chat to you about your particular situation, the charges you may have, or alternatively go along to our website, BoormanLawyers, BOORMAN, lawyers.com.au, and check out our pages there. We've got a whole heap of information surrounding laws, penalties, blog post videos, to make you aware of the situation you may be in. And of course, by all means, feel free to give me a call to have a chat about your matter and how we can possibly best represent you when your matter comes before court. Thanks for tuning in today, guys.